The Honorable Chief Guest of today's panel discussion, Mr. Justice Moinul Islam Chaudhry, His Excellency, the Ambassador of Norway, distinguished guests, ladies and gentlemen. I'd like to start by expressing my sincere gratitude to Dhaka Tribune and the Royal Norwegian Embassy for organizing this very timely discussion. And by timely, I mean this has again become the center of the nation's conversation, judicial independence. So thank you very much for organizing this. And on a personal note, I'm also deeply honored to be sharing this platform with none other than Mr. Justice Moinul Islam Chaudhry. In many ways, I believe that he is truly a flag bearer of judicial independence in Bangladesh. I'd invite all of you a big round of applause for Mr. Moinul Islam Chaudhry and his remarkable judicial career. I've had the privilege of arguing many cases before Sir's Court. Some I won, some I lost. But never for even a single moment did I come out of his courtroom feeling that injustice was done. And I can speak for other members of the bar itself. It's not just me. I think most of us felt that way about Sir. And that, I believe, is a true test of an independent judge. And this is what we want to see in the judiciary in Bangladesh. So with that, Riaz Bhai asked me a pertinent question as to what judicial independence means to me. So very simply put, and I borrow or rather paraphrase from a Canadian Supreme Court decision, which was referred to in the Masdar Hussain case, that it is when the judiciary has the freedom to render decisions as per requirements of law and justice and no other consideration. So what does that mean? It means that the judiciary has to be free from the executive branch of the state as well as the legislative branch. Secondly, it means that the judiciary has to be free from financial corruption. And last but definitely not the least, interference from non-government actors like corporate giants, pressure groups, business bodies, etc. So to be truly independent, they have to be free from all of these influences when they render their verdicts. Simply put, for those of you who are not students of law, Montesquieu, famous French judge, political philosopher, he was primarily credited with developing the theory of separation of powers, that the three organs of the state have to be separate. There has to be checks and balances for a democracy to work effectively. So he warned centuries ago, and I quote, "There is no liberty if the power of judging be not separated from the legislative and executive power." So it goes to the heart of liberty. I believe everyone present here today, we're all in agreement that executive influence over the Bangladeshi judiciary has to come to an end. And whether it's direct, indirect, overt, subtle, political influence weakens public trust in this institution. And why is public trust important? This reminds me of another interesting quote, which is by Alexander Hamilton, the famous US statesman. He wrote in the Federalist paper that the judiciary is the least dangerous branch. And why is that? Because it possesses neither the sword nor the purse, only judgment. So what does that mean? It basically means that the judges do not command armies, as we all know. They do not control budgets, as we all know. So the real source of the power of the judiciary is the confidence of the public in their independence. So the real source is public confidence. And when judicial independence is compromised, when the judiciary is politicized, as we have seen in Bangladesh, the system collapses. Many of us in this courtroom, I see a lot of lawyers or law students, I believe, in one way or another, we have witnessed or suffered the consequences of a politicized judiciary in the past. We have seen extremely meritorious and bold judges being superseded time and again in judicial elevations. We have seen Chief Justice Surendra Kumar Sinha forced to resign and leave the country over the 16th Amendment verdict. And I believe that act itself has taken the judicial independence 50 years backwards, if not more. So we've seen all of that. And history has repeatedly taught us that when courts lose independence, citizens lose faith, political voices lose protection. And this eventually weakens democracy. So to cut the long story short, the need for an independent judiciary cannot be overstated. However, when we are discussing judicial reforms, we have to remain intellectually honest, constitutionally consistent. These are issues that we cannot do away with or ignore. What do I mean by that? The legal or constitutional authority of the parliament, of any parliament for that matter, to amend, revise, replace laws made by the previous parliament cannot be questioned, as we all know. This is not something that can be debated or argued over. Every parliament has that right. Under our constitutional framework, parliament retains legislative supremacy within constitutional limits, of course, and laws made by one government can be scrutinized by, or revised for that matter, by the next one. So the current parliament does have the constitutional authority to deviate from, revise, or amend Yunus era laws. That itself cannot be debated. So the real question is not one of constitutional authority. I believe the real question is one of political responsibility. And this is where the July Charter becomes important. So the people were given commitments. Certain reforms were promised. And we are all in agreement, in particular about the judicial reforms that are necessary. Understandably, many of us at this point feel that some of those commitments are not being honored or may not be honored. Concerns have arisen, legitimate concerns, because 2 ordinances relevant to independent judiciary has been repealed by specific repeal bills, if I'm not mistaken. So one is to do with appointment of Supreme Court judges, and the other one is to do with establishment of a separate secretariat to ensure administrative independence of the judiciary. The judiciary, as we all know, was heavily reliant and still is on the ministry. So administratively, they have to be separated for true independence to be achieved. I believe we are all in agreement about these 2 reforms in principle. And the criticisms, or rather the concerns that have arisen from opposition voices, from civil society, these cannot be dismissed or disregarded. We have to address these concerns. The government has to address these concerns. However, and I've consistently said that throughout the term of the interim government, that reforms should not be rushed. Laws itself, the lawmaking process itself has to be democratic. Laws cannot be rushed, giving political urgency as a justification. And by democratic process of lawmaking, what I'm trying to say is that every law must be scrutinized and debated. Every law must be drafted, taking into account stakeholder inputs, and extensive stakeholder consultation is required when we are talking about laws that are critical to one of the most important organs of the state, which is the judiciary. Respected legal minds that I've had the privilege of talking to about these 2 ordinances in particular have raised serious constitutional objections to both the ordinances. There were concerns that some aspects of the ordinances were unconstitutional. There were concerns about inconsistencies with existing laws. There were concerns about creation of parallel legal frameworks, potential jurisdictional conflict, potential institutional conflicts once these laws are enacted. There were concerns, rightly, wrongly, matter of debate. So what I'm trying to say is that we should take time to scrutinize these laws, to carry out extensive stakeholder consultations, to actually debate these laws in Parliament. After 17 odd years or 15 odd years, we now have a vibrant Parliament with a vibrant opposition. So without an opportunity to debate these laws before such a Parliament, I personally think that these laws should not be enacted. The current government, I believe, has made their stand more or less clear. Their stand is essentially what I just said, that they believe there should be further scrutiny, they believe there should be parliamentary debates, stakeholder consultations, and then these laws should be enacted. And I am aware that members of the judiciary, at least part of them, definitely feel that way as well. And I think we need to give the government a chance to do that. That doesn't mean that we should forget about these reforms. At least till now, they have not given any indication that they want to abandon these judicial reforms. Merely, they want to pass these reforms after scrutiny, after wide stakeholder consultation. Another quote comes to mind, Edmund Burke, British statesman. He said, "Bad laws are the worst sort of tyranny. Bad laws are the worst sort of tyranny." So poorly drafted laws may eventually weaken the very institution that we're trying to protect. I'm not saying that these laws were poorly drafted, but serious concerns were raised, and some of those concerns were not addressed when the ordinances were enacted. So I personally think that we can hold two positions simultaneously. The first position can be that we strongly agree that we need these safeguards to protect judicial independence in Bangladesh. There is no doubt about that. I have been one of the proponents of these reforms as well for a very long time myself. But secondly, I hold the position that we should also support improving these drafts before placing them in Parliament. There is a famous saying, measure twice, cut once. If we cut before we measure, we end up irreversibly damaging the institution. So I think when it comes to these important laws, we need to take time. We need to scrutinize. We need to debate. I have taken up a lot of time, but I certainly hope that today's discussion contributes to the larger national consensus for an independent judiciary and to the future of constitutional democracy in Bangladesh. Thank you very much.